Hello Forensic Science. This video is going to explain the overall judicial process. So as part of our crime scene basics, we also are going to touch a little bit, very briefly, upon the judicial process and what happens once a suspect is arrested. So that's where we start our journey. But what's going to initiate this whole process is going to be the arrest of the suspect. Now, thereafter the suspect is arrested, at some point they will go before a judge and they'll be arraigned. Or in other words, the arraignment will take place. That's when the judge formally reads the charges out to the person. So that's like where you've seen on TV where it says, "You're charged of this, how do you plead?" And at that point they can say guilty or not guilty. Part of this process afterward will be, we go into what's called discovery. Now discovery is when both sides take the time to go and collect evidence to support their case. So the prosecution will be looking for evidence that they have against the suspect to try to get a guilty verdict. And the defense will try to be looking for evidence or other supports to rebut what the prosecution will say, or pretty much basically just trying to prove their innocence, right? What doesn't really get said a lot on television, because it's not as dramatic, but it is the fact, is that during the discovery phase, the prosecution is supposed to share any evidence that they found against the defense. So all of this happens before a trial even occurs. The prosecution is supposed to share. Now, not all prosecutors do it. There's some corrupt prosecutors who hold back and things like that, but that's what's supposed to happen legally, is that the prosecution shares all evidence that they have. And really, both sides are going to be sharing all evidence that they have before they go to trial. It's supposed to be, it's not supposed to be any big surprises once they get to trial, essentially. And both sides can really prepare their case that way. But so that's going to happen during discovery. So once we get through discovery, the suspect has a decision to make. If the suspect feels that the evidence that the prosecution has against them is overwhelming, or they just feel like the trial could be drawn out and overly expensive, which is a really sad thing, but it's also a possibility. They could do this for that reason too. But one way or another, the suspect needs to decide. One of their decisions could be to take a plea deal. To take a plea deal means to plead guilty to a lesser charge. So the reason why prosecutors offer this, and this is actually a huge fixture and part of our legal system, is because if you've ever heard of trial dates and things like that, they take months, sometimes years. I mean, our legal system is always very backed up. And it would be even worse if we didn't have a plea deal. A plea deal allows the process to go much faster because we skip right over the trial, which can be very time consuming and expensive for everybody involved, including the taxpayer, for covering all this. And it jumps right over that part of the process. So that's why we have the plea deal. But anyway, so mainly if the suspect feels like the evidence against them is overwhelming, or they just feel like they're going to lose the trial. That's the biggest thing. If they feel like they're going to lose one way or another, they could take the plea deal. Now, plea deal literally means that they have to plead guilty. So, again, it will be to a lesser charge than what they would be charged if they lost the trial. Otherwise, it wouldn't be so much worth taking the deal. So it's in most cases going to be a lesser charge. But they will be pleading guilty to something. And because they are going to be pleading guilty, they will be convicted one way or another. Now, hopefully the sentence won't be as harsh as it would have been if they had lost the trial itself. But that's the idea, is that they will be convicted because they, at that point, will have pled guilty. So that's one route. That's one thing that could happen. But let's say, on the other hand, the suspect they feel like they've got a good case. They've seen the evidence the prosecution has, and they feel like, you know what, I'm going to go for it. Then a preliminary hearing will occur. At the preliminary hearing, the judge will take a look at the evidence and decide, you know, is this even worth going to trial? Do we have enough to make everyone go through this whole process? Do we have enough to get a whole jury together and waste everyone's time, kind of thing? And so if there is not enough evidence, the judge will say, okay, not enough evidence, and the suspect is released at that point. We will just we arrow away essentially from the trial process. But let's say there is enough evidence and the judge decides, okay, we can proceed. then the trial begins, right? And so both the prosecution, right, the government is the prosecution trying to prove the suspect's guilt, and the defense, which of course is the suspect, will present their cases, right? And so they'll both have opening statements. They'll both describe to the jury what they will be attempting to prove and show. And then they'll have witness and expert testimony, right? So they'll have character witnesses. They'll have right to testify to the character of the people. They'll have witnesses to the scene. And they'll also have expert testimony, which we've mentioned in the past, that could be the forensic scientist who's up there on the stand explaining how they interpreted their evidence. But also commonly it's just other kinds of experts and people who are knowledgeable in their fields who can confirm or deny the claims that the one side is making over the other, essentially. And then, of course, they will both have their closing arguments, finish out their case, and then at that point, the jury needs to deliberate, or in other words, the jury needs to go and really hash it out, figure out how are they going to decide on this. Now, there's a couple of options the jury has, right? But one way or the other, this is one of the most important parts of this, the jury needs to be unanimous. Everyone has to be in agreement. It's not a majority vote situation. You can't be like, well, I mean, most of us feel like they were guilty, so guilty. It doesn't work that way. Every last juror needs to be in agreement. They need to be unanimous. So one way or the other, right? They can all agree that the person's guilty, in which case we'll go to the conviction, or they'll all agree that the person is not guilty, in which case we would go to the acquittal at that point. But they all need to be in agreement. Now, other things can happen, but as far as the scope of this class, that's all we need to know is they need to be fully in agreement, and they'll pick one or the other. Something else happens if they can't come to an agreement that we don't need to know about for our class. And there's also just important vocab to focus on here, right? Like acquittal may be a new term to you. Arraignment is typically a new term to people. These are the things I would pay more attention to. And of course that unanimous part. But okay. So, if the jury says we found the person guilty, then they go to sentencing. And then the judge will apply the sentence that goes along with that particular crime. Our last part of this is the appeals process, right? So you'll often hear that once somebody loses a trial, they can decide that they want to appeal it. So they want to go through and have the trial again. What happens with an appeal, the most important part that we need to know, is that the appeal needs to be grounded based on something unfair or something incorrectly done in the judicial process. Right? So you can't just be like, I really feel like I should have won that one. Let's try it again. It can't be like that. An appeal needs to show that something was done incorrectly. So, for example, one reason an appeal might happen is that the evidence that was admitted in the case was obtained in some legally questionable manner. Like maybe the police got the evidence without a warrant, maybe there was an illegal search, or maybe the person wasn't Mirandized, right? So the Miranda rights were not read to them first. Things like that, where evidence was used based on those, are reasons for appeal. And the whole idea is that, again, it's based on some flaw that the suspect felt happened in the procedure of the court case itself. So the last bit that's important with that is in an appeal, there can't be any new evidence entered from either side. So let's say, for example, that just for hypothetical sake, somebody had been accused of like stabbing their spouse, kind of thing. But the murder weapon was never found, the suspected murder weapon. And they go to trial, and the person who was suspected of doing the stabbing loses their case, and they're convicted. They may find some reason that they felt the case, the procedures were not followed correctly. So then they will appeal at that point. Then the next day, right after this trial's already been done, then the knife is discovered. That can't be entered. The whole idea of an appeal is that you can't have new evidence. It's based on a procedural error that was happening, where something was not done correctly for the case. And if you really think about it too, if you think about the concept of double jeopardy, that says the person can't be tried more than once for the same exact crime. meaning that like on this date they've been accused of committing X crime. They can't be retried for that. They can't be harassed about it by the government, kind of thing. So an appeal is different than that, because they're not just being retried against them. An appeal typically is to someone's benefit, is the reason why they would apply for and get an appeal, kind of thing. So that explains our overall judicial process. And thank you for watching. See you soon.